Hello and welcome back. In this podcast, we're going to look at another claim an employee might make when he feels that he's been dismissed and in unreasonable circumstances. And in this case, we're looking at wrongful dismissal. Now, wrongful dismissal is not something that's created by statute, unlike unfair dismissal. This is effectively a claim for breach of the employment contract. It's where, as it says here in posh legal term, the employer dismisses the employee in breach of either an express or an implied term of his employment contract. Now remember, that's a term that's written into the contract, or even one of those implied terms by common law, for instance, the duty of mutual trust and confidence. A key time when wrongful dismissal will apply is where an employee is given inadequate notice, and we looked at those implied notice period terms as well in an earlier lecture. It can also apply where we have constructive dismissal, which again is a term we've looked at before. Now, the same circumstances could give rise to a claim for either wrongful or unfair dismissal, but it's pretty likely an employee will choose wrongful dismissal if he has a straight choice. The reason being the damages can be bigger. There's no cap. So if you're a really highly paid employee, football manager or something like that, you want to go for wrongful dismissal because there's no limit at all. Also, you've got a longer time to bring your claim. 6 years, because we're looking at basic contractual law provisions, whereas under unfair dismissal, remember, it was only 3 months from the date of dismissal. The other key point is there is no minimum period of employment. So if you get sacked on day one in breach of your contract terms, then you could make a claim for wrongful dismissal, but you would have no rights whatsoever under the unfair dismissal legislation at that point. So summary dismissal is just pretty much where you're dismissed without being given any notice at all. So that would clearly be a breach of your contract, either of the express terms in your contract or of those implied terms which give that reasonable notice provision. And now, summary dismissal is usually going to be a breach of contract, but if the behaviour of the employee justifies it, then it will be accepted by the courts. So the question of whether summary dismissal is justified depends upon the standards of ordinary people at the time of the dismissal. So willful refusal to obey a lawful and reasonable order. This is quite an old case, and it's quite possible that things have moved on a little bit more now, in that an employee does have a little bit of discretion about which orders he accepts. But that is still in force as law. Gross misconduct. So this is where you do something which is significantly serious, justifies the employer getting rid of you on the spot. So things like disclosing confidential information, accepting a secret commission, so basically taking work on the side that competes with your employer, anything to do with dishonesty or theft, gross or persistent negligence, or breach of express rules in your employment contract. So for instance, if you're an airline pilot, and I know for instance air traffic controllers also can be sacked instantly if they're found to have alcohol in their system or to be taking drugs. So what is your remedy if you're making a claim for wrongful dismissal? Well, it's pretty simple. We're looking at normal contract law here. So it's the damages that would put you in the position as if the breach of contract had not occurred. So if you've been sacked without being given the correct notice period, the damages that you're looking for is basically the salary, the benefits that you would have earned during the notice period. And again, because we're looking at normal contract law, there is a duty to mitigate your losses. So let's have a look at wrongful dismissal. So have a read of the question, pause the recording, and then see how you get on. Okay, those are my answers, hopefully not too different to yours. So an employee is resigned as a result of his employer's serious breach of contract. That's a repudiatory breach. That would be constructive dismissal, which can give grounds to a claim for wrongful dismissal. An employee has worked for 6 years, so his implied contractual notice period will be 1 week for each complete year. That's 6 weeks. He's given 1 month's notice of dismissal. It's not enough, therefore there is a breach of contract. Where the contract states that the employee cannot be dismissed during a 3-month training period, and he's actually dismissed after 2 months, again that's a breach of the terms of the contract. That would justify wrongful dismissal. However, if the employee is guilty of gross negligence, then that would justify summary dismissal, and therefore he wouldn't be able to bring a claim there. Okay, so that's wrongful dismissal, relatively straightforward, I think, compared to unfair dismissal. The next thing we need to look at is redundancy. Now again, everybody hears the term redundancy, but it does have a fairly strict legal meaning. So if you're dismissed in a redundancy situation, we'll look at what that means in a minute, then you can claim statutory redundancy payment. And this is basically the same as the basic award for unfair dismissal. Now you may think, hang on a minute, I know people who've been dismissed and been paid loads of money. Firms often pay quite a lot for redundancy, but it's not because they're legally obliged to do so. They might be contractually obliged to do so, or they might do it just to try and maintain morale in their workplace, but it's not necessary under the redundancy legislation. So what is a redundancy situation? Well, there's kind of three tests that you might fall into. The first one is that your employer is ceasing his business. So he's ceasing to trade. So he either ceases or intends to cease carrying on this business. Or we have what we might call the geographical test. He ceased or intends to cease carrying on the business in the place where the employee was employed. And then we have on the next page the third test, which is the numerical test. So he's not stopping the business, he's not closing down a branch or an office as in test 2, but instead he doesn't need as many employees to carry out the work. Perhaps the procedure is going to be automated, perhaps it's going to be simplified. Therefore, so long as he's reducing headcount, that will still be a redundancy situation. Now, in order to apply those three tests and decide whether we have a redundancy situation, it's just a question of fact. You've got to look at all of the circumstances. Now, this British Broadcasting Corporation case is kind of interesting because in this case, a radio producer's fixed term contract wasn't renewed. So that was potentially a redundancy situation. So the employer advertised for a new person with more experience. So the first one was slightly upset by this, and she said, well, this must be a redundancy situation. I should have a payment. And the court agreed. They said that the need for a radio producer with her level of experience had diminished, so the numerical test, and as they now wanted somebody with more experience. So interesting sort of way of interpreting the test there. Now, the procedure for claiming for redundancy. First step, the employer has to meet the conditions, very similar to the unfair dismissal tests. Employed continuously for 2 years, that's the same. Must be an employee, that's also the same. And must have brought the claim within 6 months from the date of termination. Compare that to unfair dismissal, where the claim must be brought within 3 months. Now, the next thing they have to show is they were dismissed by reason of redundancy. Now, dismissal includes being got rid of. It includes failure to renew a fixed-term contract, but it also covers the situation where an employer has been laid off, so he gets sent home and asked not to come into work and doesn't get paid, or where he's kept on short time, so he might work 2 days a week where he would normally work 5 and gets paid just for those 2 days, so less than half of his normal pay. And there's a time period for that. It has to be either 4 weeks in a row or 6 weeks out of 13. Now, I know the old car manufacturers used to do this kind of thing quite a lot. When they had a stockpile of unsold vehicles, they would close down their plants or keep their staff on short time until that sort of glut of cars was cleared. You don't get a redundancy payment if there are other grounds that justify your dismissal, so perhaps perhaps misconduct. Also, your employer, as part of the ACAS guidelines, has a duty to consider whether they could re-employ you somewhere else in the business. Now, if they do that and they make you an offer of employment, if you unreasonably reject that offer, then you will give up your right, you'll forfeit your right to a redundancy payment. However, that new offer of employment has to be on the same capacity, terms, place, terms and conditions as the original employment. And also of the same status. Okay, so if you were previously the supervisor and they re-employ you as at the bottom of the ladder, then you may justifiably reject that job and you won't jeopardise your redundancy payment. If you're not sure whether or not you're going to like this new job that you're being offered, but you want to give it a go, there is scope in the legislation for a 4-week trial period. So you start the new job and you see how you get on with it. And if you leave within that 4-week period, you're still treated as having been dismissed at the start of the 4-week trial. And be careful with that, because that obviously then means you've got 1 month less to bring your claim for redundancy. Now, there's an interesting example here with Amy, which is about mobility clauses. And it's worth a moment's thought, really. Amy works for Sparkle Windows in Basingstoke. She's worked there for 18 years. And her contract has a mobility clause. So her contract provides for her to be sent to either Winchester or Bournemouth if the company requires her to do that. They decide to close down in Basingstoke. So she travels to Bournemouth for a while. But after a little while, she resigns, saying that it's just too much. She can't do it. And her employer says, well, you're not redundant because your job still exists per your contract. Well, the courts have looked at this very situation and they have said, well, no, that is a redundancy situation. She meets the criteria, she's got 2 years experience, dismissed for reasons of redundancy because there is a reduction in the headcount at the place where she was employed, i.e. Basingstoke. And therefore, the mobility clause doesn't override that. So it's quite an interesting point and one that could come up in a question. Now, finally, non-renewal of a fixed-term contract. A little question for you to have a look at. See how you get on with this and then compare your answer to mine. Okay, that's my answer. So Nick here, he's had a 3-year fixed-term contract of employment and it's not going to be renewed. Well, we know that failure to renew a fixed-term contract can justify unfair dismissal and redundancy. So potentially he might have a claim there, depending on the circumstances. Now, there has been no breach of contract because his 3-year contract has expired, so wrongful dismissal is clearly not in point here. Now, constructive dismissal is a bit of a red herring here because there has been nothing to suggest a breach of contract by the employer. Again, the contract has come to an end. Okay, so that brings us to the end of our employment law chapter. We need to still have a look at data protection, and we'll do that in the next lecture. So I'll see you there.